Hey, please, your Lordship, this is regular bail application, Lordship.
Yeah,
Today's 48 days petitioner is behind the bar, Lordship. The allegation against the petitioner is under section 22B of NDPS Act, Lordship. FIR is page number 9, Lordship.
Let a CD come, my lord.
And 40
CD
days
on
CD from Dhubri, my lord.
COVID comes PS, Lordship. Today's 48 days, Lordship.
After
we'll
10
take
days,
the very short date.
Yes, Lordship. Court date may be
31st, Lord.
no,
31st.
Lordship.
31st would
Can
be,
it be early, Lordship?
no,
27?
cannot be. It will
Next
come
week,
from part.
48 days, Lordship. Petitioner is behind the bar,
Next week,
Lordship.
Lord.
60 days is the statutory period, Lordship.
28.
28.
Can it be 27, Lordship?
28.
28.
27, 28, I am out of.
27.
Sorry, lordship.
Okay,
28,
27.
27.
Obliged.
Actually, 20.
Item 2.
Lordship. POCSO 6X, they are Lordship. Notice is required.
My,
Notice. Notice and CD.
my lord.
Yes.
Is it certified or not?
Lordship, not certificate.
Not certified.
Yes.
Okay. CD from which place?
Mm,
Duliajan.
my lord.
Duliajan, yes. CD and notice.
After 10 days,
Okay.
On 7th.
7.
Highly obliged.
Item 3.
Hey, please, your Lordship. Lordship, this is a regular bail application. The matter has been charge sheeted, Lordship, and there's a charge of POCSO involved. So, Lordship, notice may be issued to respondent number 2 and scanned copy of the TCR may be called.
TCR because.
Lordship, kindly a short date because 3 PWs have already been examined and are almost 10 months in custody, Lordship.
This is first application or second application?
Lordship, Lordship, we have filed bail applications before, also before this additional sessions judge Hojai,
Okay.
and there are rejection orders
Okay.
here.
Notice to the respondent number 2, then scan copy of the record from the
Lordship.
trial court, fixing the matter on copy.
On 2nd September.
2nd September would be too early, my lord, for notice. Can it be on 10th? 10th?
No. 7th of September.
7th.
7 September, deeply obliged.
Item number 6.
Two steps. None
Item 6.
None
is
is for
appeared.
the accused on call, lays the matter after a week in the event of subsequent non-representation of the accused, appropriate order shall follow.
Item 7.
Same order.
Item 8.
After a week, my lord.
Please, your lord.
Yes.
Lordship, there is a petitioner is before your lordship for praying for Jimma of his vehicle, which has been seized on 6/11/25. It's almost 9 months, lordship. And the impugned order is page number 35. Lordship, 123.82 gram heroin, suspected heroin was recovered from this vehicle. But the petitioner before your lordship is the owner and he was not the occupant or the driver of the vehicle, lordship. His relative, the other accused, came to his house and taken his vehicle.
No, you say in the case of Vishwajit Day,
Yes, lordship.
The 4 circumstances are mentioned there.
Lordship.
Are you
I am
falling in the category of first and second?
no, lordship. I am in third, lordship.
Third.
Third, because may I read, lordship?
Let a report be called for.
Later.
Report from the investigating officer fixing the matter. Search sheet is submitted or not?
Charge sheet notes.
Not submitted.
Scan copy of CD, your lordship.
CD will be required or report will be sufficient.
Scan copy of TCR.
SSL call for the scan copy of the case diary, fixing the matter on short date.
31st August.
31st.
Obliged.
Item 9.
May please, your lordship. This matter relating to Zimmer of vehicle, my lord. Input order, my lord, page number 46. The learned trial court rejected my prayer for Zimmer, my lord. It was placed on 24/4/26, page number 27. Seizure list. Nothing has been recovered from this vehicle, my lord.
Then why it was seized?
Because of, my lord, the arrested person stayed in a rented house. My vehicle was parked in that premises. So prospectively, my vehicle also, my lord, seized. I am not apprehended by the police in this case. Nothing has been recovered from my vehicle also.
Okay.
Everything is
Let a
recovered from the
report come
rented
from
house of the arrested accused.
let a report come from the investigating officer. Let a report be called for from the investigating officer fixing the matter on
8.
in respect to the present status of the investigation and also with respect to in regards to whether the vehicle will be required for further investigation or not.
8 September. 8 September.
May I please, your lordship? My lord, I am sorry, my lord. My matter is, my lord, 6, item number 6.
Already passed the order.
My lord, case diary may call for only. Diary may call.
Item 6 non-appears after 1.
Diary may call for only.
Okay.
6
CD.
My lord. Your lordship, may please to fix the date then.
This is from Jagiroad, my lord.
Okay.
And my lord, 60 days is mandatory, my lord. Already more than, my lord, 45 days behind.
10,
the bar.
10 September.
No, sorted.
3rd September.
3rd of September.
Item 6.
Yeah.
Item 10.
Serially,
May I please, your lordship? This revision, my lord, relating to NIX, my lord. The petitioner has been convicted by the trial court as well as the appellate court. In the concurrent finding, this division has been filed. The conviction order, my lord, start from page number 41, relevant portion, my lord, page number 67, paragraph 59. Convicted for 6 months, my lord, and to pay fine of rupees 5 lakhs.
Heard Mr. A.C. Ahmed,
AC Ahmed.
learned counsel for the petitioner. In this petition under section 438/442, reading section 528 of the BNSS 2023, the petitioner has challenged the judgment in order dated P8/2026 passed by the learned session Judge Barpeta in criminal appeal number 24 of 2026. Full stop. It is to be noted here that by the impugned order dated so and so, the learned appellate court has dismissed the criminal appeal number 24 of 2026 and thereby affirmed the judgment and order dated 2/2/2026 passed by the learned additional Chief Judicial Magistrate Barpeta in NI case number 190 of 2023. Whereby the learned additional Chief Judicial Magistrate has convicted the petitioner under section 138 NI Act and sentenced him to suffer simple imprisonment for 6 months and also to pay a fine of rupees 5 lakhs with a default stipulation. Peruse the petition and the documents placed on record and also peruse the impugned judgment and order passed by the learned appellate court in criminal appeal number 24 of 2026 and also the judgment and order dated 2/2/2026 passed by the learned additional chief judicial magistrate in case number 190 of 2023.
During pendency of the appeal, I have paid 1 lakhs, my lord. Page number 70.
Issue notice to the respondent returnable in 4 weeks. They be taken by speed post and also by usual process within a week from today. Registrar shall call for the record from the learned courts below. Mr. Ahmed, learned counsel for the petitioner, submits that during the pendency of the appeal, the petitioner herein has paid a sum of rupees 1 lakh. Where is the proof?
Page number 70, 70.
And in support of his submission, he has referred to Annexure 3 at page number 70 of the petition, which is an order dated 22nd of April 2026 passed by the learned session judge Borpeta. And he submits that pending disposal of the appeal, the sentence so handed down upon the petitioner hearing may be suspended. Fair enough. Accordingly, taking note of the submission of Mr. Ahmed, learned counsel for the petitioner, and also considering the facts and circumstances on the record, especially considering the fact that the petitioner hearing has already deposited a sum of rupees 1 lakh, being the 20% of the awarded amount. Before the learned appellate court, this court is inclined to suspend the sentence so handed down by the learned additional chief judicial magistrate Borpeta in NI case number so and so, and affirmed by the learned session judge Borpeta in criminal appeal number 24 of 2026 till disposal of this petition. List after 4 weeks.
Obliged.
You have filed an IA.
That may be, I may be allowed to withdraw that. As already
you may-
order has been passed in main revision.
The petitioner is allowed to remain on previous bail. In view of the order passed in the revision petition, the interlocutory application stands closed.
Obliged.
Item 12.
12 or 11. Delay क्यों है?
May I plead your lordship? Lordship, under section 528 of the DNS, my lord, quashing of this FIR and granting the pre-arrest bail, my lord. In this case, my lord, one case is pending, CR case, my lord, before this judicial magistrate, Asa Sirsar, my lord. Next date of appearance 7/9, my lord. That case is, my lord, totally false case, my lord. Neither police registered this case, my lord. Thereafter, accompanied one representation made this superintendent of police, my lord. I have annexed this representation is annexure page 19, my lord. Annexure 2. That case is, my lord, property dispute matter, my lord.
Annexure 3, the story doesn't seem to be improbable, my lord. Lordship may kindly see. The victim has specifically named, my lord, he has witnessed the occurrence. At page 20, on 31/12/2020 at about 2 a.m. during the night, while my husband was absent from home and I was putting my children to sleep, then after resting on the bed, I heard some sound noise outside the house. I immediately got up from the bed and noticed the light of a fire. I came outside the house and saw that the accused person had set fire to my house and thereafter fled from this place. In the light of the fire, I could clearly see the accused person. As a result of the fire, my house was completely burned down and reduced to ashes.
My lord, that case is, FIR is unregistered, my lord. I have enough, that is, my lord. Thereafter, my lord, if that is serious matter, my lord, why police is not registered this FIR, my lord? And although, my lord, one title sheet is pending, my lord. I have the plain copy also, I have annexed, my lord, annexure one, my lord. That dueling houses, my lord, complainant falsely made in paddy field, my lord. One kacha house, my lord.
No, you have lost the CR case number 40 of
Yes, the
2024.
Complainant lost, my lord.
Complainant.
My lord. I have a earlier file, my lord, one title suit, my lord, that is annexure one, I have annexed, my lord. That is pending,
No,
my
no,
lord.
on this CR case,
Notice has been issued, summon has been issued.
Next date of appearance is 7/9, my lord. That's why petitioner approached before this court. Pre-arrest bail, my lord. Petitioner was ready to appear before this court, my lord. Any
no,
condition
no,
may be
this
given.
is criminal petition. This is not bail application.
No, my lord, some section is there, my lord, non-bailable. That's why, my lord, approached before this court, my lord.
No, you file bail application.
My lord, petitioner not filed this CGM, my lord,
Pardon?
directly appear before this court, my lord.
No, that's all right. You
Yes,
file
my
bail application. Yeah, why this criminal petition?
My lord, quashing this FIR also.
Maybe.
Your charge has been paid, my lord. Page 26. Court has taken cognizance under so and so against you and you are hereby summoned to appear. Court has taken cognizance, your lordship. And he was
CR case,
asking.
you go and apply for bail there. This jurisdiction under 528 is extraordinary jurisdiction. And while your remedy is available by way of filing bail application, why should we exercise this power? Hmm? Hard miss, learned counsel for the petitioner, and also hard miss. The Bhoya learned additional PP comes senior advocate assisted by so and so for the state respondent number 1. In this petition under section 528 of the DNSS 2023, the petitioner has tried for quashing the share case number 40 of 2026 pending before the Court of Learned Chief Judicial Magistrate Kasar Silsor, and also for granting bail. Bail to the petitioner as the learned Chief Judicial Magistrate has taken cognizance against the petitioner under section 448, 143, 436, 427, 506, 511, 33 against the present petitioners. Here is the petition and the documents placed on record. Let notice be issued to the respondent, returnable in 4 weeks. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. A recessal call for the scan copy of the record from the Court of Learned Chief Judicial Magistrate Kasar Silsor. Place the matter after for which, though the learned counsel for the petitioner submits that the petitioner may be granted the privilege of PRS bail, yet while exercising the jurisdiction under section 528 of the BNSS 2023, this court is not inclined to entertain the pair. Instead, the petitioners are relegated to avail appropriate remedy by filing appropriate petition under appropriate provision of law. Place the matter after 4 weeks.
Item 13.
Your Lordship, I pray for a short passover for the timing and.
Not timing today. There is a reference also.
For the
And
timing,
at
Your
2
Lordship,
p.m.
the
we have
council is
some
in May.
other fixed matters. Or we will adjourn the matter.
For the timing, Your Lordship. the
Not for
council is in
timing.
May.
Okay.
Pending
Item 14, sorry, item 15.
May I please, your lordship?
Mm.
This is criminal petition for pushing the NBW order, lordship, but petitioner has not appeared before the court one, 1/4/2026, lordship.
Where is the impugn order?
Impugn order, lordship, page number 53, lordship.
Why you could not appear before the court on that day?
Lordship, some communication gap, lordship, communication gap errors for the technical problem, lordship. Petitioner has lost this mobile phone, lordship. Due to that, lordship, it is difficult to communicate with the engaged counsel, lordship, and know about the fixed date, lordship. Petitioner is a uneducated person, lordship.
Lordship,
I have mentioned in paragraph, ground B, lordship, page number 7, lordship. I have mentioned details, lordship.
he has annexed the order dated 1/4/2026 at page 53.
Mm.
Next, it was fixed on 17/6/2026. Then thereafter, what has happened? He has not annexed anything.
There, lordship, we have filed on 17,
No.
lordship.
That order is there. Page number 55.
53? Oh,
5.
fine. 17.
Actually, there is a two NBW order. One is 1/4/26
Yes,
and 17/6/2026.
17/8 is also gone.
And 55 is the another order, lordship.
Art Mr.
Alim Sheikh, lordship.
Learned counsel for the petition. B. Bhuya, learned additional PP for the state respondent. In this petition under section 528/438 of the BNSS 2023, the petitioner has challenged the order dated 1/4/2026 and 17/6/2026, by which the learned judicial magistrate first class Collier Nagaon has issued non-bailable warrant of arrest against the present petitioner. The learned counsel for the petitioner submits that the petitioner is an accused in PRC case number 40 of 2024, arising out of Collier PS case number 111 of 2023 under section 14 within bracket 1, or 14 within bracket 1, capital A of Child and Adolescent Labor within bracket PNR Act. And the said case is pending before the court of learned judicial magistrate first class court, and that on 1/4/2026 and 17/6/2026, the petitioner could not appear before the learned trial court on account of communication gap between him and the engaged counsel, as the petitioner has lost his mobile, and that the petitioner is ready to face trial and will appear before the learned trial court, and therefore he has contended to set aside the impugn orders dated 1/4/2026 and 17/6/2026,
And subsequent order also, lordship.
and all subsequent orders by which the non-bailable warrant of arrest was issued against the present petitioner. Ms. Boya, learned additional PP, submits that fixing a date, the petitioner may be directed to appear before the learned trial court and to apply for regular bail. Para, taking note of the submission of you are an educated person.
Lordship.
You are uneducated person.
তুমি uneducated নাকি বলো?
Yeah, yes, Lordship.
This
And daily labor.
case
also.
is registered under section 14(1)(a) of the child and adolescent labor.
Yes, Lordship. And
Act.
petitioner also the labor of the said brick factory, Lordship. And with his
You
wife
are
female member.
labor or you are the owner of the brick factory?
No, Lordship, no. I am for Surhab Ali, Lordship. Surhab Ali is the labor, Lordship, of the said brick factory from where the child labor was recovered, Lordship.
No,
And-
why the case has been registered against you then?
Yes, Lordship, my child also recovered from this brick factory, Lordship. I am working that brick factory with my all family, Lordship.
Okay, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition by directing the petitioner
Next day.
to appear
Next day,
before the court of
20
learned judicial magistrate first class Kolia Nagaon on
On 9 September.
9th of September and to apply for regular bail. And in the event of filing such an application, the learned trial court shall consider the same in accordance with law. Till then, non-bailable warrant of arrest issued against the petitioner by impugn order dated 1/4/2026 and 17/6/2026 and by all subsequent and on all subsequent dates shall be kept in abeyance.
Obliged.
Item 16.
May it please your lordship, this is a 528 criminal petition filed by the petitioner wife seeking quashing of the proceeding in CR case number 2C/26 pending before the learned court of JMC in Hojai, or in the alternative transfer the matter from Dibrugarh to Hojai. So the facts of the case, your lordship, is that I married to the respondent number 2 on 12/2/2029. 15 years we stayed married. And your lordship, after shortly after 15 days of the marriage, I have suffered immense and continuous physical and mental torture. And the respondent number 2 demanded dowry. Initially, he demanded 15,000 and a motorcycle, which my father fulfilled it, even after giving all the articles and Sridhan in our marriage. And later on, he again demanded rupees 10 lakhs, your lordship.
Okay, this is in fact a transfer petition.
Yes, your lordship.
Let a notice.
But why this is under section 528? There is specific provision in the BNSS 2023.
Your lordship, because actually we are seeking for the quashing because financially we are not able to do two matters simultaneously. Already title suit has been stayed.
No, what is your pair here? For quashing the proceeding or for transfer?
Lordship. Basically, we
Yes,
want a
also.
transfer.
Transfer.
Yes, your lordship.
But there is no, there are two prayers, Mala, quash the impugned criminal proceeding and transfer the HCR.
Heart miss, your name?
S. Nisha Sultana.
Learned counsel for the petitioner and Ms. D. Bhuya, learned additional PT. Come, senior advocate. Madam, state is not a party here.
They have made it.
Oh,
state
yes,
for
yes,
some-
one, yes.
Just a
yes.
form.
State respondent number 1. In this petition under section 528 of the BNSS 2023, the petitioner has tried for causing the criminal proceeding being CR case number 02 within brackets 02C of 2026 and stroke or in alternative to transfer the said CR case number 02C of 2026 from the court of learned JMFC Dibrugarh to the competent court at Huzai, Assam. Peruse the petition and the documents plus on record. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by speed post upon respondent number 2 and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number one since Ms. Moya entered appearance and received notice. Recess shall call for the scanned copy of the record from the learned trial court. List the matter after 4 weeks. Is there any interim period?
She prays for stay, but Lordship, without hearing the other side, Lordship may not stay the proceeding.
At what stage the case is pending?
Your lordship, domestic, DV is in the appearance stage and the divorce of the title suit is already stayed at Dibrugarh and notices has been issued to the respondent number 2. And right now, CR is filed in Dibrugarh.
Till return of the letter list. After hearing learned counsel for both the parties and considering the facts and circumstances on the record, till returnable date, further proceeding of CR case number 02C of 2026 under section so and so stands state. List of authorities.
Item 31 for hearing matter upgraded.
May I please go on? My lord, on the earlier occasion, your lordship has queried that whether the section 281 of the Succession Act, verification of the probate application by one of the attesting witnesses is mandatory or not, my lord. So I have some case laws, my lord.
Okay.
There are 4 judgments, my lord. 2 of the judgments are from the coordinate bench of this honorable court, my lord, which held that the section is directory in nature. Under the first citation is from the court, my lord, page 9, para 20. Page 9, my lord, para 20, the relevant paragraph. May I read, my lord? Citation.
Not necessary.
No, no problem. Copy.
Then the second judgment,
Yes, my lord. Second judgment is page 16. And relevant para is, my lord, 34, 35, 36, page 33 and 34.
Which judgment you are referring?
No, serial, yes. 34, 35, 36, my lord.
okay.
The third one is page 36.
Hmm.
Relevant para is 10, 11, 12, 13. Page 39, 40 and 41. Ten, 11, 12, 13. Side of
Page number 9.
paragraph is of the file. The last one, my lord, is a old judgment, my lord, 1957. There are four, my lord. 4 and 5.
Okay. There is no decision of Supreme Court on
No,
this,
my
right?
lord. I have searched, my lord. Because the first one is from 26 July, my lord. Tibu Thakur, the first judgment.
Okay.
I have not found any Supreme
Okay.
Court judgment.
There is no such judgment. And I will check that. There's no such judgment on section 281. That's why.
Okay. So, what remains to be heard today?
Only this point, my lord.
This point. Your part is over?
No, I'll just. Finish. Your lordship. Your lordship, section 281, your lordship. Because it has to be read with section 63, 68 and evidence act also. I'll that, you know. Section 281, your lordship says, where an application is for probate, the petition shall also be verified by at least one of the witness of the will, wherever procurable, in the manner to the effect. So and so it has been given, your lordship. So here the word shall has been used. And if your lordship see section 63 also. I go take it, your lordship, to section 68 of the Evidence Act, which section 68 of the Evidence Act, if your lordship see. Proof of execution of document required by law to be attested is very important, your lordship. If a document is required by law to be attested, it shall not be used as evidence until one of the attested, at least one of the call for the purpose of proving its execution, if there is an attesting alive and subject to process of the court capable of giving. Provided that it shall not be necessary to call an attesting in proof of the execution of any document, not being a will, which has been registered in accordance with Indian registration, unless the execution by the person to whom purpose to execute. Your lordship, here I have proposed. Here, this section 68 would have to be read at 281 also, your lordship. That's like 63. 281 also says shall. The form, your lordship, that form may not be there, but the substance has to be there. No judgment has said that the substance should not be there. And directory is only, it cannot be directly because of this explanation, your lordship. Because if you are 63, 68, then everything will be directly, your lordship. 63 also like that. 63 also says that way, your lordship. 63, if your lordship see section 63. Execution of every testator not being a soldier, so and so, your lordship. Here the testator shall sign or affix the mark onto the will, or to shall be signed by someone to his own. Then the signature or mark or the signature of the person signing by shall be so placed. Everyone is shall is so placed that it shall appear it was intended there to give a writing of will. Then 3 is the will shall be attested by two or more, each of whom has seen the testator sign or affix his mark or the will, or has seen some other person sign the will in the presence direction of the testator, or has received from the testator personal acknowledgement, signature or mark so and so. In each of those shall sign the will in presence of the testator. These are everywhere the word shall has been used. So it cannot be used as directory, your lordship. Because the judgments have not dealt these issues, your lordship. 281 read with because there is no Supreme Court judgment, and the Supreme Court judgment has not stated anywhere that section 63 or anything is directory, because they have laid down a condition that it is mandatory in character, your lordship. So there is no question of directory here also. Because if it is made directly, the whole purpose will be futile, your lordship. That cannot be done, your lordship. That is one of my submissions. The second submission which I have to put, your lordship, I was referring to the schedule, your lordship. Schedule, because if your lordship will see section 263, your lordship. Yes. That's it. Your Lordship, 268. Proceeding of district judge in relation to probate and admission. The proceeding of the court of the district in relation to granting of probate and letter shall shave hair and others provide be regulated so far in the circumscribed code of civil procedure. So here, Your Lordship, it will be guided by CPC, and Your Lordship, the schedule, will doesn't have a schedule. Suit, the probate application gave a schedule, and the affidavit gave another schedule, Your Lordship. So, Your Lordship, what is not stated, the plain cannot be taken in affidavit evidence. That is also there. And they have, if Your Lordship, they have scheduled, if Your Lordship see the affidavit, it is there. They have given the schedule A, movable, immovable property. In the probate application, only immovable property was given. And they have made a schedule there with boundaries, which is not there in the will also, Your Lordship. And Your Lordship, if Your Lordship see the will also, they have not signed an attesting witness, and they have admitted the cross also. There are two, PW2 and PW3. They have admitted that they have not signed the attesting witness. They have not seen the will also. They say we have not read we don't know the contents of the will. They have signed it. If Your Lordship see the cross, it is very clear on that here. Then Your
No,
Lordship,
on the other day, you have pointed it out.
here I pointed because I just summarized it there.
No, not necessary to.
Then Your Lordship will see, I give one judgment, Your Lordship, that.
But my humble submission is that the
Let him complete.
No, I just. This is, Your Lordship, it is Supreme Court judgment, Your Lordship, on attestation and execution, Your Lordship.
copy it again.
Copy, I would want copy.
Move copy it.
Good, oh, sorry. Hey, get that.
আপনার judgment copy.
I read him. Copy. Copy. Your Lordship will see para 8. What do you know? Citation, yes.
Yes.
Para 8, Your Lordship. Para 8 says, to say will has been duly executed, the requirement mentioned in clause A, B, and C of section 3 succession are to be complied with. The testator has to sign affix the will, or it has got to be signed by some other in his presence. The signature mark of the testator or signature of the person assigning it has to appear at a place from where it could appear that it was marked by signature intended to have the will. This is very important. If Your Lordship see the will, it is not there. Then see, the most important point which was presently concerned in this appeal is that the will has to be attested by 2 or more witnesses, and each of those witnesses must have seen the testator sign or affix his mark to the will, or must have seen some other person sign in the will to presence, the direction of, or must have received from the testator personal acknowledgement of signature. This is important. Or the signature of such other each of this. So Your Lordship then goes to next section, the para 10. It talks of section 68. Section 68 speaks as to now a document required by law has to be attested, can be proved, Your Lordship. Because attestation has to be there, then it can be proved, Your Lordship. Then if this is there, Your Lordship, and then Your Lordship, I just refer to Your Lordship para 11 also. I just do para 11, para 12. This has taken care of the whole thing, because Your Lordship will have to see the chronology of the section 63, 68, 71 of the Indian section with section 281. Then that has to be read with section 68 of the Evidence Act, Your Lordship. Then the scheme is complete, Your Lordship, which has not been satisfied the probate application, Your Lordship. It was for that reason the first trial court has rejected the application, Your Lordship. That's my submission, Your Lordship. No. Because I have said our cross and all this, that documents I have already pointed out those things, Your Lordship. Okay.
Yes.
My lord, my humble submission is there. In the instant proceeding, my lord, all the attesting witnesses are subsequently examined, my lord. It is admitted that they had not verified the probate application, but subsequently they are examined, my lord. And second was, my lord, regarding section 268 of the Succession Act, as my learned senior friend referred, my lord. For this, my lord, kindly refer to page 44 of my this case laws, my lord. Page 44 of my citation.
Page
44.
yes.
Paragraph 4, my lord. Verification of a petition required under section 281 is similar to verification required for pleadings, including a plaint under order 6, rule 15 of the CPC, and has no greater effect or value. Omission to verify or defective verification of a pleading is a mere irregularity within section 99 of the CPC and is never fatal. The provision of section 281 of the Succession Act is less drastic than that of order 6, rule 15, and an omission to verify or a defective verification of a petition for probate cannot have a more serious effect than that of a plaint. A pleading must be verified by the party or by some other person acquainted with the facts of the case. A petition for probate is, however, required to be verified by an attesting witnesses. A petitioner for probate has no legal authority over an attesting witness and cannot compel him to verify the petition. Paragraph 5, my lord. He may be bound to get the petition verified, but an attesting witness is not bound to verify it at his instance, and he would be helpless if the latter for any reason refuses to verify it, even though it contains nothing but the facts. Therefore, the legislature has deliberately laid down that the petition should be verified only if an attesting witness is procurable, that is, can be procured by the petition for the purpose of verification. If the petition is not verified by an attesting witness, the petitioner can always excuse himself on the ground that he could not procure any attesting witness to verify it. I therefore respectfully agree with the view expressed in Ramasina, my lord. So, my lord, all these judgments says the language of the section, my lord. Within bracket, it is written when procurable, my lord. All the judgment says the language of the section itself denotes that it is not mandatory, my lord. It is directory, my lord. All the judgment says. And second ground is that if the subsequent proceeding, all the attesting witnesses are examined, my lord, then it is in compliance of the section 281, my lord.
Okay. Over. Heard Mr. Borua, learned counsel for the petitioner, no, for the appellant, and Mr. Chaudhary. Learned counsel for the respondent, argument concluded, judgment reserved. Deep level.
Order item number 28.
Can you file written submission?
You can. But when you are going to file it?
Your Lordship,
When you are going to file it?
I will file it. File it soon. Next week. I'll try today.
Okay. Or not taking a file.
But a copy of the argument may be served upon us.
Definitely.
Oh.
That's not an issue.
Sometimes I was supposed to file their lawsuit if last occasion they sought for time.
Opposite party. I bought her.
What about?
After some time.
Lodge.
29 for orders.
My lord, on the last application, my lord, it was fixed for hearing, my lord. And DCR was called for, that has not been received, my lord.
TCR received.
No, my lord. I have checked the record, my lord. That has not been received.
Record to receive. Otherwise, today listed for finally dispose of lordship.
But without record, can we hear the matter?
Yes, ma'am.
My lord.
Without record, can we hear the matter? Record has not yet been received. Heard Mr. Roman, learned counsel for the petitioner, Mr. D. Bora for the respondent. Office note dated 19/8/2026 indicates that a scanned copy of the record of ZR case number 6940 of 2024 has not yet been received. Accordingly, it is provided that a registrar issue urgent reminder to the learned trial court for transmitting the scanned copy of the record and list the matter on
14th September.
14th of September.
My lord, regarding item number 22, my lord, the respondent has taken time, my lord, regarding item number 22 during mentioned, my lord. So the date has been fixed for 9/9, my lord. It's too long, my lord. Can it be on 2nd or 3rd, my lord?
22,
22.
9 September.
No, it is too long, my lord. I have talked with the respondent, my lord. He is there.
Okay.
Can it be 2nd or 3rd, my lord? Kindly, my lord.
3rd September.
3rd, my lord. Deep lord.
My lord, this is on 14th of September, my lord. Obliged.
I'm sorry, my lord.
Item number 30 by VC mode.
Yes, please, Milos. I am appearing for the petitioner in this matter, Milos. Milos, the steps were taken to serve the respondent number 2, and the case diary was earlier called, Milos. And thereafter, Milos, due to some technical issue on the last date of hearing, we could not appear. So, Milos, there was no date. So, we have already taken the steps.
Mr. Goswami, service report is available with you.
We have not received any instruction regarding service notice. So I will take instruction to check whether service is completed or not.
And Milos, case diary may also be retained, Milos.
Case
If it is
diary
on
retained.
record.
Goswami?
Not.
No, there is one order dated 14/7/2026 for retaining the case diary.
Case diary not received yet. We have not received the case diary also.
Heard Mr. A.K. Roy, learned counsel, appearing through VC. And also heard Mr. Goswami, learned additional PP for the state respondent. Mr. Goswami submits that he has not received any instruction in respect of service of notice upon respondent number 2. However, learned counsel for the petitioner submits that speak upon respondent number 2 was taken on 6/8/2026 by speed post.
By speed post, by speed post, then we have. It was from the registry to PP office, then I have to take risk.
Registrar list this matter on short date call.
My lord, so may I request, please, my lord, meanwhile, my lord, interim protection may be granted, my lord. Since while, my lord, he is unsafe. The petitioner is unsafe, my lord. This is 6 POCSO matter, my lords, and he was already granted the transit bail in Delhi, my lords. And my lords, thereafter, my lords, there is no protection to him, my lords. And since we are in Delhi, my lords, it's become difficult to appear, my lords. So, my lords, my humble request is to grant at least interim protection till the next date of hearing, my lords. My lords, in the order whereby the transit bail was granted, here it is clearly mentioned by the victim that there is no such act of any sexual took place, my lords. And thereafter, my lords, in 164 statement, it was added, my lords, later on.
No, maybe the victim is not before the court today.
That is why, my lords, I'm sorry, my lords, but kindly allow me to kindly give
We'll
grant, my lords.
fix a very short date. We'll peruse the case diary also.
Please,
Registrar put up one up-to-date office note in respect of service of notice upon respondent number 2 by tracking the consignment in the website of the postal department on short date.
On 3rd.
3rd of September. And on that day, Mr. Goswami learned additional PP shall produce the case diary before this court.
My may I request that it may be 8th of September, my lords, please? 8th of September.
Okay, okay, 8th of September. In the event of failing to produce the case diary before
obliged.
this court on that day, interim period of the petitioner will be considered.
Timing
Please,
28.
lords, much obliged.
Deeply obliged.
28.
My lords, I'm seeking a week's time to file the affidavit, my lord. Another week, just one more week.
Mr. Kolita is absent now.
He's in another one.
After some time.
Timing 13.
May I please, your lord? Lordship, the FIR is in page 13. Lordship, the allegation against page 13, Lordship, type copy.
Where is the impugn order?
Impugn order is in page 38, Lordship. Lordship, charges had been filed, but non-bailable warrant of arrest has been issued against you on 17/7/26, page 38. Firstly, on 18/6 bailable warrant and 17/7 non-bailable warrant. The case is fixed on 2/9/26.
Yes, Mortagor?
Yes, let him appear till then only.
Heard, Mr. Your name?
Yes, Nag.
Learned counsel for the petitioner, Mr. Mortagor, learned additional counsel for the state respondent. This petition under section 528 of the BNSS 2023, the petitioner has tried for setting aside recalling the order dated 18/6/2026 and subsequent order dated 17/7/2026, whereby non-bailable warrant of arrest was issued against the present petitioner. Learned counsel for the accused, for the petitioner submits that the petitioner is an accused in their case number 471 of 2025, arising out of Ratabari case number 54 of 2025. And in the said case, after completion of investigation, police submitted charge sheet against the petitioner on being charge sheet number 97 of 2025 on 31st of July 2025 under section 196, 299, 325 stroke 3 within bracket 5 of the BNSS 2023 read section BNS 2023 read section 13(1) of the Assam Cattle Preservation Act. And thereafter by order dated 18/6/2026, learned trial court which court had issued a warrant of arrest against you.
Chief Judicial Magistrate, Tribunal. CGM Tribunal.
Chief Judicial Magistrate, Sribhumi. has issued non-bailable warrant of arrest against the petitioner. You have filed an application there.
Yes, Lordship, absent petition.
And do the learned counsel of the petitioner file an application there? The said petition was dismissed and thereafter issued non-bailable warrant of arrest against the petitioner. The learned counsel for the petitioner submits that the petitioner is ready to face trial when the next date is fixed
2/9/26.
and he will appear before the learned trial court. And therefore, he is contended to interfere with the impugn order dated 18/6/2026 and 17/7/2026. Mr. P. Borthakur, learned additional PP submits that the petitioner may be directed to appear before the learned trial court. Before the learned Chief Judicial Magistrate, Sri Bhumi. Accordingly, taking note of the submission of learned counsel of both the parties and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition by directing the petitioner to appear before the court of learned Chief Judicial Magistrate Sri Bhumi on or before
2/9.
September.
Second.
on 2nd of September 2025 and to apply for regular bail, and in the event of filing such an application, the learned Chief Judicial Magistrate shall consider the same in accordance with law. Till then, non-bailable warrant of arrest issued against him by order dated 18/6/2026 and 17/7/2026 shall be kept in abeyance.
Highly appreciated.
Timing 28.
Mr. Borthakur, you see, you have been granted sufficient time to file your affidavit.
1 more week, my lord. It is under process, my lord. Just 1 week, I will file it. My lord may fix it next Monday, my lord. I will get it filed.
Heard Mr. Polita, learned counsel for the petitioner, and Mr. Borthakur, learned additional PP. No, sorry, learned counsel for the contender, Mr. Borthakur submits that the contender will file an affidavit and the same is under preparation and he tries for listening the matter on next Monday. They are allowed to list the matter on
Pardon.
partner matter,
7 September.
7th of September.
Before that, last they will make their endeavor to find this.
Yes, we will file.
However, liberty will remain with the petitioner to reply to the affidavit filed by the respondent contender.
Obliged.
For bail hearings, 21.
The Honorable Court was pleased to call for the entire matter, as well as the evidence of the witnesses, my lord. Last occasion, my lord, there is an order of the Honorable Court, my lord. Order dated 29/5/2026. The trial court was directed to examine the victim first. After the petitioner has liberty to approach the court against filing evidence of the victim by way of additional affidavit.
Whether the victim was examined.
It was examined, my lord. And we have filed the evidence in affidavit also, my lord, as directed by the Honorable Court. That is your lordship will find. Annexure 4 is the copy of the evidence of the victim. It starts from page 29, my lord.
Last time.
So how many witnesses have been examined so far?
Most probably she is examined and she is the main witness. Because mother actually was not examined because by the IO, because he has not supported the case of the prosecution, because there was a family dispute regarding some property dispute by them. And if your lordship go to her statement also, there is nothing except bad touch, my lord. And for the and at the time when she lost the FIR, she was a major, my lord. And she states about incident of 2020, 21, 22.
And your lordship, may kindly come to item number 31, petition, my lord, item number 39, my lord, page 4, paragraph 8, my lord. That the petitioner begs to state that one Sofikul Islam, who is the friend of the petitioner, took the said vehicle from the petitioner just for trial, as the said vehicle is new one, but said Sofikul Islam, without the knowledge of the petitioner, brought the said vehicle to Rongia, but suddenly the police from Rongia police station came to the residence of the petitioner and seized the said vehicle, and
my lord, this is the fact, my lord, at the time of getting interim protection, my lord, he has stated, and in fact, that vehicle was, my lord, recovered from the house of Safiqul Islam, my lord, on that particular night without number plate. That vehicle was suspectly, my lord, moving in that particular area. And during investigation, my lord, it also comes to light that all these accused persons, my lord, their statements also details also available, my lord, by breaking the, my lord, 3 locks, and thereafter, my lord, breaking the grill, my lord, on that particular night, stolen all these articles. Now investigation is still going on, my lord. Those articles not yet recovered, my lord.
Okay.
And Joinal, my lord, interim bail, who was granted, Joinal Hawk, he is, my lord, one of the main accused. He was the driver of one of the vehicles, Safiqul Islam. And on that particular night, from the CDR detail, it reveals that he was in continuous contact at about, my lord, 2 and, my lord, that is specific, my lord, timing is also mentioned in the mobile number, my lord. At 2:39 AM and 2:50 AM on that particular, he was in continuous contact with Safiqul Islam. my lord.
Okay, CD.
Yes, well, I will hand over the studio.
My lord. Civil, our statement has recorded. The loss of NDC, petition number 1 and 2 of item number 37, they were taken custody for first time for 3 days. Thereafter, they protested in the court. Again, they were taken custody for 2 days. And all the persons are taken custody 2 times. And their statement has been taken. They clearly refused. Nothing has been recovered. No statement has been there confessed that we are person. 5 days, they thoroughly interrogated, beaten them, tortured them, my lord. Actually, they are not committed offense. So, in the police custody period, after over the police custody period, they are remanded to the jail house of my lord. And mandatory period, my friend say that 9 days. No, my lord, it is a punishment for 3 years, and one is up to extend to 7 years. The 321, it is punishment up to extend to 7 years.
No, my lord, 3:30.
And 305, only 3 years punishment, up to 3 years. Now, let's kindly see, police, they have been thoroughly interrogated. Nothing has been recovered from their operations. And so as the anticipated bail, 2 persons are concerned. Our vehicle, my lord, suppose some vehicle is moving here and there, it is established that that vehicle is involved for committing the dacoity, my lord. So those facts to be lots of we will appear. Nothing has been recovered from it. We have badly tortured, my lord. Inhumanly tortured, but they are not disclosed anything. Nothing material from the records, my lord, except their suspicion, my lord. Nothing.
Well, I would like to only pointing out regarding the 60 days, well, 331(4). Whoever commits lurking, house trespass or house breaking after sunset and before sunrise, in order to the committing of any offense punishable with imprisonment, shall be punished with imprisonment of either description for a term which may extend to 5 years, and shall also be liable to fine. And if the offense intended to be committed is theft, if the offense intended here theft 305 A, my lord, the term of imprisonment may be extended to 14 years.
Maybe.
So, my lord, that may be extended to 14 years.
Okay, we'll see.
And regarding item number 39, Arshad Ali, my lord, he specifically stated that vehicle was handed over to Safiqul Islam, and that vehicle was in fact also, my lord, recovered from the house of Safiqul Islam. So regarding Arshad Ali, your lordship may, my lord, looked into. My lord, that is, yeah, but otherwise,
no one has
statement
been
against him is
disclosed.
also there.
Badly tortured them. They are
Okay.
dead for that.
Item 25.
May 25, my lord, in this case, charge sheet submitted, my lord.
Then, Mayor, I pray the interim be made absolute, or Mayor Lordship protects me for any 15 days I go and appear.
Item number
25.
25. Charge sheet submitted.
Charge sheet submitted.
You go and appear before the trial.
Lordship will protect me for 15 days, or Lordship will make the interim absolute, either ways.
Okay. Till then, we'll fix the date. Correct.
Sometime later. Because my son is out. Son is on bail. Son and daughter-in-law are in the scuffle and I'm running around. I'm a school teacher. After 2 weeks on 8th September. I pray Lordship makes the, if Lordship would be pleased to
No.
Then
You
can
go
it-
and apply for regular bill there.
8
Till then,
September protection.
till 8 September, it will continue.
Obliged. Item 26.
May I please your lordship? Such a pre-arrest bail application lodged. Such
Hmm.
a earlier occasion case diary was available and the injury report was called for lodge.
Yes.
Today CD probably taken back for this one.
Lordship, may I kindly peruse the earlier.
No, injury report was called for.
Injury report was called for.
Lordship is reflected in the order itself, lordship, last occasion.
After some time. It will go.
Yeah, at two, lordship, kindly, lordship.
No, not at two.
After some time, we'll get the instruction. from-
Deeply obliged.
27.
No. Case diary not received, my lord.
Lordship, kindly fix a short date, Lordship.
Hmm?
Earlier, Lordship, 18 days.
POCSO is there.
Yes, sir.
Heard, Mr.
H.A. Rashid on behalf of A. Dewan.
Learned Counsel appearing on behalf of Mr. A. Devan, Learned Counsel for the applicant. Mr. Borthakur for the respondent. Borthakur, what is the status of this service report?
My lord, regarding notice also, I will get the instruction. my lord. See, my lord, regarding notice also, I will get the instruction. my lord.
Okay.
CD no.
Mr. Borthakur submits that he has not received the case diary and also not received any instruction in respect of service of notice upon respondent number 2. Accordingly, it is provided that SSL lays the matter on
Short date.
On 31st August.
Yes.
On that day, Mr. Borthakur shall produce the case diary before this court along with the service report upon respondent number 2.
Guidance for admission. Item number 17. Authorization.
Lordship, pursuant to your Lordship direction, the matter has been forwarded by the director to the department, Lordship. For Lordship, may kindly the second paragraph, Lordship. Second page, Lordship. That from the above report, it appears that Lordship got it. The petitioner has already withdrawn the amount of so and so, which is 60% of the total amount of NPS account, and the remaining 40% of so and so is still in the NPS account. Further, CPF account deduction has been made since his date of joining in Sunapur Public ME School in respect of Kamul Islam Sode, Assistant Director. Further, it is stated that aforesaid writ petition is to be listed again on so and so with a direction to place the appropriate instruction before the court about the status of provisional pension of the petitioner. In view of the government is requested to issue appropriate instruction in this directorate to release the provisional pension in respect of the writ petitioner. This letter communication is made, Lordship, on 18th August, Lordship. Now I have taken the instruction that matter is being processed at the Lordship directorate, sorry, department level, Lordship. So they paid for some time, Lordship.
No, why the remaining amount of this NPS?
Lordship, the NPS amount which he has already been drawn, Lordship, he will have to refund it or he will have to be adjusted. with the-
It can be adjusted.
So regarding the provisional pension amount, we may be granted some time. In the meantime, we will, Lordship, give the appropriate instruction.
Okay. Heard, Mr. Alam, Learned Counsel for the petitioner. Mr. Dotto, Learned Standing Counsel for the Secondary Education Department, and Madam Deka for respondent number
1, 5 and 7.
5 and 6. 5 and 6?
5 and 7, Lordship.
5, 7 and 8. 5, 7 and 8. Mr. Dotto, Learned Counsel for the Secondary Education, Standing Counsel for the Secondary Education Department has produced a letter dated 18/8/2026, and on the basis of the said letter he submits that in respect of sanctioning of provisional pension to the petitioner, the director has written a letter to the commissioner and secretary to the Government of Assam, Department of School Education, on 18/8/2026, and accordingly, Mr. Dotto submits that he may be granted some time to obtain up-to-date inspection in respect of the said letter. We are allowed to list the matter after 2 weeks.
First week of September, my lord.
No, after some time. Yeah, after.
Okay, pardon me.
What matter, Lordship?
On 14th
Lordship,
September.
Lordship.
By that time, they are expected.
No, sure, Lordship. I'm coordinating, Lordship.
On next date, Mr. Dotto shall apprise this court about the status of the said letter
Obliged.
in respect of sanctioning of provisional pension to the petitioner. The letter produced before the court today shall be marked as Annexure K and be taken to the record.
Item 18. Pardon me.
Yeah, please, your lordship.
So pay protection is approved.
Yes, your lordship.
Approved. Now
This
the
is of
inspector
your
will prepare the bill.
lordship.
Who will prepare the bill? Inspector?
Yes, your lordship, the inspector. We have already written a letter to the inspector.
Okay. Pardon?
The information already be sent to the to the inspector of school also, your lordship.
So the matter in Dispur is over.
Yes, your
Now
lordship.
it is in the inspector's
Inspector of school, your
office.
lordship.
Because of the non-fixation of pay and delay, my pension and other benefits have not been finalized. Because of this delay in paper.
No,
Now
now the,
Now it has been done.
Now it has been done,
Now
your
it has been
lordship.
done.
you have seen the,
Yes,
so should we close this petition?
Lordship can dispose of by giving a direction, Lordship, to finalize my pension and other benefits, Lordship.
Whether such prayer was there in this petition?
Lordship, my prayer is not there.
It is
Then-
not there, your lordship.
Lordship, my prayer was something else, Lordship, because I have come during my when I was appointed as a regular principal, taking the scale of pay of the principal and pay protection. In the meanwhile, I have retired because of the delay. Now I have retired in Lordship January 2020.
Okay.
Lordship
Heard,
can
sir.
still say, Lordship, that my other
Heard Mr. Das, learned counsel for the petitioner, and Ms. Terampi, learned standing counsel for the education department,
1 and 2, your lordship.
1 and 2. Secondary education department. During the course of hearing, Ms. Terampi has produced one letter of the director and also one letter of the Deputy Secretary to the Government of Assam addressed to the Director of Secondary Education, wherein dated 19/8/2026, wherein it is stated that pay protection in respect of the present petitioner as Principal Sarna Lakshmi Higher Secondary School, District Kasar, has been approved. At rupees 88,700 and 80 stroke in the pay scale of itu letter to provide to and on the basis of the said letter dated 19/8/2026, the director has written to the inspector of school, written one letter to the inspector of school on 20th/8/2026, asking the inspector of school to take necessary action on the fixation of pay in respect of Srimati Gitasri Das, principal, now retired, Sorno Lakshmi Higher Secondary School, District Kasar. And since the payer of the petitioner has already been satisfied with, this court is inclined to close this petition. Close this petition. Mr. Das, learned counsel for the petitioner, submits that though the petitioner retired from service in the year
On 31/1/2026.
31
1
1
2026.
2026. He has not, no, the petitioner has not yet received the pensionary benefit, and as such, he submits that the inspector of school may be directed to finalize the pensionary benefit of the petitioner. However, it appears that no such payer has been made in this petition by the petitioner. Even then, this court hope and trust that now the inspector will proceed to fix the pay of the petitioner and also finalize the other pensionary benefit and release the same as soon as practicable.
Obliged. May be reported for finance department.
Okay, Mr. Solia for finance department.
Obliged.
Obliged.
Standing item 26. Prohibitions.
As per the instruction from my office, my colleague.
Matter. Huh? Yes.
Item number 2, as per instruction from my office, my lord, CD is in court number 23, man.
Here,
Yes, man. In court number 23.
let it be on Monday then.
Monday, my lord.
Monday,
Along with the injury report.
along with the injury report. Heard Mr. D. Medhi, learned counsel for the applicant, and Mr. Borthakur, learned additional PP for the state respondent. Mr. Borthakur submits that he has not received the case diary and also the injury report, and as per his instruction, the case diary is lying in the court number 23. 23. Accordingly, it is provided that Regis shall list this matter before the list this matter on Monday along with the case, and on that day, Mr. Borthakur shall produce the case diary before the court.
Until then, case there may be written.
No, he produced, he will.
Item 19. Pardon me.
My lord, I have received instruction from the IO, my lord. The reply.
So, whether, what is this, the case is pending now? Investigation is this?
The trial is going.
Yes, trial is going on.
trial is
Two
going-
witnesses have been examined.
Two witnesses have been.
Scan copy of the record called for,
Yes.
Yes, record is.
received.
Record received.
So, detailed hearing will be required.
My lord, there is no allegation against her. And kindly see the page
No, no,
number 41.
some materials are there. It is not that you are absolutely innocent.
Page number 41 is the CCTV footage details, my lord, given there. Only 3 candidates running even manipulated, which is shown.
My lord, in the scan copy of the CD also, my lord, although some details, my lord, only the.
CD is not available with
Oh,
you.
yes, my lord. All details, my lord, all these details right now I have found in this report, my lord, because.
Not
the-
available.
Not, detailed CD would be required, my lord.
Heard Mr. O. Loskor, learned counsel for the petitioner, Mr. Borthakur, learned additional people for the state respondent. Mr. Borthakur has produced the instruction which he has received from the concerned IO. And he also submits that the case diary is not available with the scanned copy of the record received from the learned trial court.
The CD is available, but my lord, all these details, my lord, that I have not found in the FSL report. I will have to check it.
And no, he has received the CD, but all the materials in respect of CD and the CDR and FSL report are not available in the scanned copy of the record. And as such, he has contended to call for the entire CD with the CDR and also the FSL report from the learned trial court. Where allowed, RESSL, accordingly, RESSL call for the entire copy of the CD.
Case diary, my lord.
Case diary. Entire copy of the scan copy, scan copy of the entire CD, fixing the matter on
8 September.
8 September.
Item 20.
My lord, this item may be kept as part heard.
Okay, RESSL keep the matter as part. RESSL is the matter as part. Problem.
Please, Your Lordship. May please, Your Lordship. In this case, the allegation against the son that he has stolen some gold ornaments. My lord, it is in the FIR, in the last line, it is stated that there is a doubt of involvement of the parents, my lord. Otherwise, my lord, nothing has been seized from us, nothing has been found from us, my lord. And this petitioner is facing trial, my lord. In the lawsuits, we'll find the FIR last line, my lord. I have a doubt that the parents of Amit Roy is involved in the incident, my lord. This is the only sentence, my lord. And as because the police was harassing at that incident, my lord, these petitioners took bail, my lord. And therefore, her name also sent up for trial, my lord. Only this much, that her name has included in that column, accused sent up for trial, my lord.
So
Otherwise, nothing is against me, my lord.
Savitri Roy is the mother of
Mother of
Amrit
Amit
Roy.
Mother of Amit Roy. Against me, nothing. my lord.
Yes, Borthakur, is there any matter?
Yes, my lord, here main allegation from the FIR, it reflects that, my lord, allegation
the
of
son.
Amit Roy. And there is only, my lord, in that FIR last portion stated that উক্ত ঘটনাৰ লগত অমৃত ৰয় মাক বাপেকো জড়িত আছে বুলি সন্দেহ হয়. That is the contents of the FIR. Thereafter, my lord, during investigation, several statements of the neighboring witnesses also recorded, my lord. From their statement also, it reveals that, my lord, main offense was, my lord, actually committed by the Amit Roy. Thereafter, my lord, in presence of those independent witnesses, Amit Roy was called to the
residence of the present petitioner, then in fact, Omit Roy disclosed before them that yes, I committed the offense. Thereafter, he sold all these jewelry articles to one Ma Sitola jewelry regarding that. And regarding the involvement of the father and mother, one statement of the Omit Roy, my friend has pointed out that is there that after commission of the offense, Omit Roy, the mother and mother was also called to the residence of the informant, then mother told the informant that you don't disclose it to anyone, don't even in fact intimate to the police. We will return all your jewelry, that is the statement of the Omit Roy. And from that, because she tried to conceal all the incident, and also stated before the informant that please don't disclose this incident to police. So regarding that, as only that aspect is there regarding the mother of the, otherwise she is not at all involved in commission of the offense, but trying to conceal the fact and ask the informant not to state before police. And my friend also gone through that statement. He has. Otherwise,
No, whether that will be sufficient
yes,
to.
otherwise it seems that she could have been at the time of. Otherwise the discharge application. The stage of at the time of discharge also, he can be discharged. Otherwise, on these materials.
Maybe now the petitioner is before this court by filing the present petition. Yes, Mr. Das.
That statement I only found, in the record.
No, whether that is sufficient to charge her.
Whether it was made out of love and affection for her son or for some other ulterior motive, that I cannot say from the other statements, But that is there. They tried to dissuade the victim not to approach the police. So that was there, Apart from that, I did not see any other involvement.
Okay, we'll close the proceeding.
Close. Diploma. Thank you.
Seconds for hearing 32 to 34.
May it please your lordship. Lordship, we have preferred this review petition seeking review of the judgment and order dated 10/2/2025 passed by this honorable court in MFA number 27 of 2016. Your Honor, in the judgment, there are two issues, lordship, in the present case. One issue is with regard to refund of distance paid on account of wrong chargeable distance, and the second issue is the refund of terminal charges. So far as issue number one is concerned, lordship, the matter was remanded back to the learned tribunal to decide the matter fresh, Your Honor. And the second issue, that is the refund of terminal charge, that was, lordship, dismissed. Then against that issue, the refund of terminal charge, lordship, we're seeking review of this judgment, lordship. In the judgment, lordship, our categorical submission is, lordship, was that that in the circular dated, that is 5/6/2007, the circular says that in the 50 goods stations, lordship, terminal charges will not be applicable. So there are 50 number of stations are listed, lordship. And based on these stations, lordship, the railway cannot levy charges, terminal charges. And on these issues, lordship, the coordinate bench of this honorable court in MFA number 44 of 2024 and 105 of 2000. 42 of 2017 and 105 of 2017, the honorable court held that the railway can levy only terminal charges only on those 50 stations, but beyond that they cannot charge terminal charges. Being aggrieved with the judgment of this honorable court passed in those two MFAs, lordship, the railway preferred SLP before the Supreme Court. The honorable Supreme Court dismissed the SLP. And lordship, the present status of that issue is that the terminal charges will be leviable only on those 50 goods stations. Now, lordship, In this case, Lordship, at the time of hearing, Lordship, the respondent have categorically made their submission that based on that circular and the judgment passed by the Honorable Coordinate Bench, Lordship, the terminal charges will be leviable only on those 50 stations. And the present 2 stations, that is the booking station and destination, Halvad and Dikam, Lordship, that those 2 stations did not fall in this categories, Lordship, 50 goods station. And based on that submission, Lordship, we have also relied upon those 2 judgments. And we have
No, these 2 judgments were produced before the court at the time of hearing of the
Yes, Your
petition.
Honor, and my submission is also recorded in paragraph number 8, 11, every.
Now, on what ground you are preferring this revision?
Honor.
Review petition.
Since the scope of the review is very limited, Your Honor, the review can be exercised when there is an error or mistake apparent on the face of the record. Second, Lordship, review can be exercised for any sufficient reason. Now, Lordship, this sufficient reason is elaborated in the judgment passed by the Honorable Supreme Court, Lordship, which says that it can be misconception of fact or law by a court or even an advocate. So, by invoking the doctrine actus curiae neminem gravabit, Lordship, an application for review may be exercised. This is my submission, Lordship. So, now, I have filed this review petition. Against that petition, Lordship, the respondent have filed their counter affidavit. And again, I have filed a reply to that counter affidavit. And I have annexed that judgment of this Honorable Supreme Court. The Supreme Court judgment, page number 112 to 122.
No, that decision of the Supreme Court was already produced before this court.
Yes, Your Honor. This judgment, Inderchand Jain's judgment is basically I have filed in the reply, Lordship. But the Honorable Supreme Court held that if there is a sufficient reason, Lordship, which was elaborately defined in this judgment, which I would like to peruse, Lordship. In that judgment, it is said that if there is a mistake on the part of the court or the advocate, Lordship, the maxim that is actus neminem curiae neminem gravabit may be invoked, Lordship. So, Lordship, my humble submission is after the passing of this judgment, another judgment was passed by the Honorable Justice Midul Kolita, sir. And that judgment I have perused, Lordship. I would like to peruse.
No, that subsequent events will not help you.
Correct. My submission is, Lordship, since there is a judgment of the coordinate bench and the same judgment was upheld by the Honorable Supreme Court.
On that ground,
facts may be appreciated by the
no. On that ground, it cannot be. Cannot be.
Another submission.
Even there, if there is any mistake, that cannot be rectified in a review petition.
For a moment, Lordship, can I, Lordship, peruse the judgment?
There are several other decisions also. One of the celebrated decision is a Lily Thomas case.
Which judgment, Lordship?
Lily Thomas case.
Lily Thomas.
You find it out?
Another submission is, Lordship, in the impute judgment, Lordship, the learned trial court, in paragraph number 17, last 3 line, Lordship, have categorically observed that this point is otherwise also covered by the decision of this bench. In the case of Messrs. Manas Salt Iodization Industries Limited, decided in OA number 16 of 2009 on 18/6/2015. This OA number 16 of 2009 pertains to item number 33, Your Honor. That is why we have tagged this item number 33 with item number 32, Lordship. Based on the decision passed in item number 33, that is OA number 16 of 2009, MFA 65 of 68/2015, Lordship, the learned tribunal passed this judgment, Lordship. And in that judgment also, Lordship, one of the submission of the respondent claimant is that terminal charges can be levied only on those 50 stations. So, Lordship, my submission is based on this judgment, when there is a reference of this another order, Lordship, similar case, Lordship. So, my humble submission, Lordship, this fact may be appreciated in the judgment.
No. In review petition, facts cannot be appreciated.
But this was skipped by this court, Lordship. This was due to
Maybe,
oversight, Lordship.
maybe. Scope of review petition is very limited. There are several decisions. Even some mistake is there, then it cannot be reviewed.
Lordship,
Yes.
subsequent.
But in this case, I have filed my counter affidavit. Review is as per section 114 of the CPC, read the order 47 or rule 1 of the CPC. So why, as per section 114, what is the provisions for review in the order? If there is any error or mistake apparent on the face of the record in the judgment or order, then that can be reviewed by for correction. But in this case, they whatever they're seeking for go through the whole judgment to be further examined further with the fresh decision, but for giving the fresh decision after examining the evidence further. So this is not sustainable in law, my lord. So in my counter affidavit, in para 8, Lordship will kindly see in para that it is humbly submitted in a review petition, it is not open to this honorable court to appreciate the evidence and reach a different conclusion. The appreciation of any evidence on record is fully within the domain of the appellate court. In the instant case, MFA 27 of 2016 has been passed after recording the finding of the fact and reached a conclusion on application of various railway board circulars, letters, provisions of law as provided as produced as evidence. That conclusion cannot be assessed in a review petition unless it is shown that there is an error apparent on the face of the record. Further, it is submitted that to permit the review petitioner to argue on the question of appreciation of evidence would amount to be controverting a review petition into an appeal in disguise. It is well settled that review proceedings are not a way of an appeal and have to strictly confined to the scope of ambit of Order 41, Rule 1 of the Code of Civil Procedure 1908. Further, in para 9, that it is a pertinent to mention here in that under Order 47, Rule 1 of the Code of Civil Procedure 1908, a judgment may be open to review entirely if there is any mistake or error apparent on the face of the record. An error which is self-evident, an error which is not self-evident and has to be detected by a process of reasoning cannot be described as an error apparent on the face of the record for the court to exercise this power of review. It is important to mention here that in exercise of jurisdiction under Order Section 114, read with Order 47, Rule 1 of the Code of Civil Procedure, it is not permissible for an erroneous decision to be reheard and corrected. That it is settled law that on exercise of review jurisdiction, this honorable court cannot appreciate the evidence to arrive at a different conclusion, even if two views are possible in a matter. In view of the aforesaid legal proposition, it is well settled that the power of review can be exercised for correction of the mistake, but not to substitute a view. Further, the power of review is not an inherent power. The term mistake or error apparent by its very condition signifies an error which is evident from the record of the case, does not require detailed examination, scrutiny, and elucidation either of the facts or the position. An order of decision of a judgment cannot be corrected merely because it is an erroneous in law on ground that different view would be taken by the court tribunal on the point of the facts of or law. In the instant case, while exercising power of review, the honorable court cannot seek any appeal or any appeal over its judgment or decision.
Okay, madam. Okay, all right.
My lord, in support of my contentions, my lord, I like to submit some various department addition of this honorable court also and the Supreme Court also, but they have rejected this review petition on the same ground, my lord. This is my judgment, my lord.
Lordship, one more submission I would like to make, Lordship. In paragraph 12, Lordship, it was observed that it is also to be noted that here that the appellant in the memo of appeal had taken a stand that the railway board has been issuing various circulars from time to time for levy of terminal charges, and all the circulars so issued by the railway board are binding. When Lordship, the circulars of the railway board are binding, then the circular dated 5/6/2007 is also binding, Lordship. And based on this circular,
My
Lordship,
lord, it is my humble submission, whatever it may be, if they are agree for dissatisfied with this judgment, if they are relying on other decision of this honorable court, they can approach to the higher forum to challenge this order. Otherwise, the merit of the case cannot be decided in the review petition, my lord.
so these facts were, Lordship, due to oversight, Lordship, it was not considered by this honorable court, Lordship. So 5/6/2007 is applicable in the present case, and based on this circular, the decision of the coordinate bench and the Supreme Court judgment is squarely covered in this case. And subsequently, Lordship, in MFA 44 of 2024, the honorable court again held that the railway can levy terminal charges only on those 50 goods stations, Lordship. If there is a difference in the opinion, Lordship, the Lordship may kindly refer this matter to the larger bench, Lordship. If Lordship is not
No, in a review petition, it cannot be.
because, Lordship, here there are two issues. So far as a refund of terminal charges is concerned, one issue is with regard to rail circular dated 18/9/2007, and another circular is 5/6/2007. Both the issues are different. And the Honorable Supreme Court, as well as the coordinate bench of this court, directly held that this
Madam, you see, a coordinate bench of this court, this court is not, may not follow that decision because no law was laid down there, no discussion was there. Simply stated that this is this.
Yes, my lord.
Lordship is correct, but when there is a
And in the Supreme Court also has not deliberated upon it. So no law is laid down. So this court is not bound to follow that decision.
even if there is no law laid down by the honorable court, Lordship, even though this issue is still there, that railway can.
You go and file appeal before the Supreme Court.
Yes, my lord. So, my lord, that order already
No,
passed.
the principle is that in a review petition, we cannot reappreciate the fact
Yes,
and
my lord.
arrive at a different finding. This proposition is well settled in the case of Lily Thomas. You find out the Lily Thomas case?
I will.
Yes.
Obliged.
My lord, it's my humble prayer, my lord. The item number 3334 is filed by me, my lord. These two items, one is for terminal charge, another for terminal charge and graded concern. These two items may be segregated and give me heard separately, my lord.
Okay.
33, 34.
And these two may be listed before the appropriate bench, Lordship. This is the criminal bench, Lordship. So it may be listed before the civil bench one.
No, is it part-heard? Are those matters a part-heard matter?
Only the MFA 27. 27 was heard, Lordship.
Okay. As per roster, civil is the matter. Heard, Miss, your name, please.
I'm Sharma.
Learned counsel for the petitioner, Miss Chakraborty, learned senior.
Item number
Learned
33,
senior
34, I am the appellant.
counsel, railway. Argument concluded, order reserved. SSL list MFA number 68 and 74.
68 of 2015 and 74 of 2017.
Obliged.
Both the cases will be heard separately, my lord.
Itanagar bench item by PC mode.
My lord, am I audible, my lord?
Yes, Mr. Ratan, you are audible.
My lord, I have just received the instructions. I'll be sending it through mail through the court master.
Yes.
Right now.
Yes.
My lord, here my lord knows for the Dibang multi-purpose dam project.
Yes.
An area of more than 3,600 hectares was acquired for the NHPC. My lord.
Yes.
Now the present land in question of 142 hectares at Bismarck Nagar, this is sought to be acquired for project affected families, my lord.
Yes.
Whose villages are going to submerge
they are going to be fully displaced, my lord.
Mm.
Now, as per our instruction from the NHPC and the government, the NHPC says that they have enough land to resettle them within the already acquired land, more than 3,600 hectares.
Hmm.
So they don't require this extra 142 hectares anymore. Now
Yes.
they are ready to resettle and rehabilitate the 41 families within their own land, which they already acquired, my lord. So in such a situation, when the requiring body do not want to acquire extra land, the government cannot refuse it. And say that this land should be compulsorily acquired, my lord. So there is a communication from the Ministry of Power and also the NHPC for denotification. So in such a situation, the state government cannot refuse not to denotify when the requiring body itself says that they no longer require this land, my lord. It is our stand, my lord. I'll send a written instruction
Yes.
through mail, my lord.
Yes.
May I submit, my lords?
Yes, Mr. Razo.
Our paramount interest is to see that the PAF's project affected families are properly rehabilitated and resettled. We will not leave any stone unturned for this purpose. But the issue is that as far as this particular land is concerned, we do not require it for the moment for the purpose of rehabilitation and resettlement. We have adequate land which can be done, and therefore we have requested for the withdrawal, and that the state government, as rightly pointed out, you cannot insist that a particular land has to be acquired if the acquiring body doesn't want it. Therefore, my lord, and no prejudice would be caused to the other side because we would have deposited the full amount in this honorable court. That amount is lying, and they will get in within a short period. I think everything will be settled, and the project affected families will be properly, efficiently, and correctly rehabilitated and resettled. Our entire aim is to see that they have proper justice and adequate justice is done to them, which we will do to them by giving them wherever land is required and other types of compensation. We will do it. Therefore, at present, this matter may be adjourned for some time till that decision is taken by the government. If the government doesn't withdraw, what are the consequences? If they withdraw, then what will be the consequences will arise after some time. So my lords may adjourn it for a suitable time.
Okay.
Yes, Mr. Das want to say few
Things in this case, my lord. I have seen, my lord, what the last time also they were referring to section 93.
Mm.
If you see section 93, my lord,
Mm.
it's not that government now taking a stand that they want to withdraw it.
Mm.
If you see the affidavit, my lord, kindly see, my lord.
But if he is not
What-
willing, then this petition may be disposed of with liberty to give
My
it to
lord
him
will
at
kindly see, my
at a
lord.
later stage.
My lord is asking something, so I am giving an answer to it. And I am giving an answer to my learned friend, Mr. Ratan. What is the stand they have taken in their affidavit in 58? And why they have made a U-turn at this particular juncture? Please look into one particular one paragraph.
Mm.
What is their case in the writ petition? Please see. My lord, they can't, my lord, at any moment of time, they see, today I want to withdraw it. Under what circumstances you want to withdraw it? My lord, the notification which has been issued by the state
Those are
government is
not
under section 10 of the
justice
Balipara
can
Act.
be, if
Please,
a
Mr.
requiring
Raju,
body
I am
wants to
just,
withdraw it, it wants
Mr.
to withdraw
Raju,
it.
please, I am
Those
giving
are
a
not
reply. Why you
justiciable
are not?
matters.
I am giving a reply to my lord. My lord, it is under section 10 of the Balipara Act. It is not under Lara Act where the notification has been issued. Now they are taking the help of a Lara Act under section 93. It is under section 10. If you
Mutual
see, my
agreement,
lord,
we agreed
please
that
see.
Lara Act would apply.
Please see, my lord, at page 173 of the writ petition, my lord. No, writ petition. 1 second. Please see 58 of 2026. See the prayer first. Now today they are saying withdrawing, and the state is saying that we want to withdraw it. See whether they can. Please see page 53. Their case was not again denotifying. Please see. Here they come for the first time. 53, kindly see. 53 and their writ petition. Please see. One, issue a writ of searcher or any other appropriate direction, so and so, setting aside the land acquisition award dated 1/8/2025, passed by the Deputy Commissioner so and so under section 10 of so and so, approved by the government of Arunachal Pradesh by letter dated 28/7/2025 in relation to land acquisition.
My merits, we
notification.
are not arguing. Why is my learned friend arguing on merits?
see
We
what-
are not going into the merits. It is my petition. We are not going into the merits. We are only saying adjourn it for some time. What is
Again,
no
my lord,
prejudice being caused to him?
I am giving
He
an
can
answer
argue
to
all
him.
this later on.
My lord,
if the
I am
need
giving an
arises.
answer. Why my learned friend is trying to disturb me, my lord? Your lordship
Because
is asking me
unnecessary
just, I am giving
time
a
of the court
reply.
is being consumed. When the matter
Mr.
is
Dasa, you say, this is their writ petition.
I'm sorry.
This
Yes.
is their writ petition.
That's why I am
If
saying.
they are not willing to pursue the same,
No, if they are not pursuing the same writ petition, very well. Let them not pursue the writ petition. Their whole case is not that.
we are not,
My lord,
not that we
please
are
see.
pursuing in view of the
Their case is not this, my
later
lord.
developments.
Their case
We are
is something
saying
else.
that subject to our
What-
rights
what
to
they
come
are
back
saying.
if the withdrawal is not allowed, we have a right to come back. That's what that we are saying. We are saying we have a move for withdrawal. State government is considering as a and if that doesn't fructify, keeping that right open, we may be this petition may be disposed of. And
My lord,
after recording the state government statement.
please, if you see, my lord, your lordship judgment, please see the judgment. Please see the judgment of this court.
The judgment, etc., is not
Mr.
relevant.
108.
no, no, Mr. Das,
Yes.
what purpose will be served by hearing you? Because if they want to withdraw this petition, or they want to, state government want to withdraw the notification, then
If suppose the state government withdraw the notification,
Mm.
then nothing remains in my case.
Mm.
That they want to 93, they want to withdraw the denotify, denotify.
How
the
can he say
notification.
compulsorily acquire my land?
Why my learned friend? I don't understand. This is not the habit here, my lord. Please, my lord, your lordship is putting a question to me.
Mm.
What happened? Number one, my lord. If they doesn't want to press the writ petition is different.
Mm.
What my learned friend Ratan is saying, they are not interested, they may withdraw the notification.
Mm.
Now, one, if they withdraw the notification under section 93, my lord,
Mm.
after from 2010
Mm.
till 2026, after fighting for 16 years, now they are withdrawing it. I will show the stand of the government, my lord. I will show the stand in the government in the affidavit, my
93
lord.
says they'll be adequately
Today,
compensated. for
they
this.
are trying to take a stand saying that we want to withdraw it. I will show the stand of the government. Today they are making a U-turn, my lord. Stand of the government.
Mm.
I will
No,
satisfy
okay,
before this court.
Mr. Das,
Yes.
let the state of Arunachal Pradesh file an affidavit
Yes.
bringing on record the instruction they have received.
And I will give a reply to it also.
Yes.
madam. Whether they can withdraw or not, I will give a
Yes,
reply.
yes.
I'll give
My
a
lord,
reply.
We'll
my
fix
lord,
it
may I
later.
make a small submission?
Yes,
My lord,
yes.
of course, my senior counsel, Mr. Das, was right. At the earlier point of time, the state was with the writ petitioners saying that once notification has been done and all assessments award has been passed, it should be acquired, the compensation should be paid. Now there is a subsequent development. Subsequent development is that the NHPC and the Ministry of Power, they are saying that this land is no more required. Now, that is the issue. Now, therefore, we cannot go with our earlier stand.
Okay, my lord.
Because
Let my
subsequent
learned friend give
developments
a
have been
affidavit
occurred.
in this case.
So,
They want to, I will show the stand of the government
Okay,
advocate.
okay.
That they said that they doesn't have any land. And today they are
we
saying.
were ready, we
Yes.
were along with the writ petitioners that their land should be acquired. But there are certain subsequent developments because of which
Okay,
when the
Mr.
requiring...
Rotan, Mr. Rotan, you file one affidavit, short affidavit, bringing on record the instruction you have received from the government.
Yes, my lord. I'll
Heard,
do that, my lord.
heard, Mr. Raju, learned additional
Let the
solicitor
statement be
general.
recorded, but the statement may be recorded, statement may be recorded, what he said.
Okay, okay. And also heard Mr. N. Roton, learned advocate, additional advocate general for the state of Arunachal Pradesh, and Mr. D. Das, learned senior counsel, assisted by Mr. Learned counsel for the respondent. During the course of hearing, Mr. Roton, learned additional advocate general, submits that he has received written instruction from from where you have received it, Mr. Roton?
From the government, the Commissioner
From the
Land Management.
government, that as the requiring body, has reported that the land so acquired is no longer required. They have no longer required for the purpose of rehabilitation of the project affected families. They have asked the government of Arunachal Pradesh for withdrawing the notification, acquiring the land of the respondents. And the government of Arunachal Pradesh has also received one request from the Director, Ministry of Power, Government of India, dated 21st of August 2026. And in that view of the matter, Mr. Raju, learned additional solicitor.
My statement is this, my lord. We are
Additional
concerned about the project affected families, and that we will take utmost care as
Mr.
for rehabilitating and resettling them, and that we have adequate land.
Mr. Raju, please, Mr. Raju, please don't disturb. I am dictating the order.
I'm sorry. I'm so sorry.
কি বলো? Submits that the matter may be adjourned and to be listed after some days. Accordingly, pair of Mr. Raju stands allowed. Registrar list the matter on
After 8 weeks, my lord.
After 8 weeks. Oh, this is too much.
in the last part of September.
Yes, ma'am. Last part.
22nd of September.
Yes. Yes, ma'am.
In the meantime, Mr. N. Roton, learned additional advocate general, shall bring on record the instruction he has received by filing a short affidavit and also indicating the stand of the government.
Yes.
May I request for 23rd instead of 22nd, my lord, 23rd instead of.
Okay, 23rd. Okay.
And one more, my statement may be recorded that we will rehabilitate and resettle the project affected families, and we have adequate land. This may be recorded, my lord.
Once the affidavit is on record, my lord, then my lord record, then my
This-
No, I am only making my statement.
Yes.
Why? What objection you can have recorded?
I also pray that this may be recorded.
I do
NHPC.
not want to do anything which will be adverse to the PAFs.
Yes, my lord. My lord,
Mr.
I also
Raju
request that
submits
this.
that the
NHPC.
NSPC is very much concerned with the interest of the project affected families, and they will take all necessary steps for their rehabilitation
And resettlement.
And resettlement, my lord.
and resettlement.
And we have adequate land, my lord, and we have adequate land for the purpose.
And that the NSPC has adequate land to rehabilitate the project affected families. List the matter on 23rd of September.
Only copy should be furnished to us.
Okay, Mr. Roton, furnish a copy to Mr. Das well in advance.
Yes, my lord.
Great.